Hi everyone, thanks for coming along. Appreciate there's a lot going on today in the world on a few different fronts, so it's kind of you to come along, go at your lunch break. Also want to acknowledge the traditional owners of this unceded land on which we gather, and also say that I am speaking in a personal capacity and my views are mine alone. Truth in political advertising. An issue that remains very topical. When I started writing this paper at the end of last year, it'd been on the horizon, but it really, since I started writing, has only gained topicality. Just last week, the ABC had a report about some misleading and false political advertising in relation to the Western Australian election that they traced back through some circuitous routes to a National Party representative saying the Labor Party were going to introduce a gold tax when there was no evidence of that. You'll probably all recall the Medi-Scare situation. I'm not sure if any of you got that text message. I don't think I did, but when the Labor Party sent out a text message saying that the Turnbull government was going to privatise Medicare just before the 2016 election. And of course, over the last 4 years, Donald Trump has been a prodigious liar in office, and particularly in the build-up to, during and subsequent to the US election. So I think, for a number of years now, but particularly in the last year, there's been a renewed focus on the question of, well, what can we do about misleading, inaccurate, deceptive communication and advertising in the electoral context? A question that has both legal dimensions, political dimensions, societal dimensions. And one of the potential partial solutions to this problem that's been raised is Section 113 of the South Australian Electoral Act, which is a truth in political advertising provision. We've seen, in 2019, on being elected, Zali Steggall MP proposed introducing one at a federal level. Just last year, the ACT Legislative Assembly enacted one. In late 2020, the Joint Standing Committee on Electoral Matters released its report on the 2019 election, and both Labor and the Greens supported enacting a federal truth in political advertising provision, although the Coalition Majority Committee refused. And just this week, Labor's released their draft national policy platform, and that commits to introducing a truth in political advertising law if they win government at the next election. And even if you drive around the streets of Canberra, you might have even seen the Australia Institute's van bringing attention to the fact that it's legal to lie in a political ad and shouldn't be. So I think we're moving towards, at both the federal level and in other jurisdictions, replicating the South Australian model, or even expanding upon that model, which to me brings to mind a very obvious question. What about the Constitution? Thanks to the ABC for this great photo, by the way. And particularly the implied freedom. Any law regulating political communication, particularly electoral communication, is going to raise difficult questions about compliance with the implied freedom of political communication. That issue has been considered only once before in the case of Cameron and Becker by the South Australian Supreme Court full bench. But as everyone would know, implied freedom jurisprudence has changed significantly in the subsequent 25 years, almost unrecognisable really from those early days. And so I think there's an open question about the extent to which that case is useful in providing guidance. Before that case, the High Court in a related case, Evans, in relation to an electoral law that sought to do a similar thing, but they read it down so it only applied to sort of the process of actually voting. The High Court said a more broadly framed law would give rise to issues, and they recommended that framers of such a law must consider the importance of ensuring free speech is not unduly restricted. So there's this backdrop of the implied freedom that's only become more pronounced since South Australia introduced their truth in political advertising law, but surprisingly it hasn't been given much scholarly engagement. Most of the focus at both a policy level and an academic level has been on the efficacy or desirability of such a law. There's been minimal consideration of constitutionality. George Williams, in a parliamentary research paper in 1997, said, Australia also faces constitutional problems, full stop. And so I guess what I have hoped to do with this paper is continue that train of thought and look more deeply at the intersection between these laws, prospective laws, and the implied freedom. I've got a draft paper, but it's very much a draft, so looking forward to your constructive and critical comments. So I thought today I'd just sketch out the context briefly, then apply the current tests to these laws. The South Australian and ACT laws are almost identical, so we can consider them together. For the implied freedom nerds in the audience, I thought I'd also touch on whether the Gageler approach may lead to a different result, and then think about, well, what does this mean for the way we design these laws, and briefly touch on the comparative context. And I think for me the thinking process for that latter stage is, there would at some point be a point reached where a law on political communication in electoral context is no longer constitutional. And so but equally, the narrower a law is, the less effective it's going to be. And so of course that's the trade-off, and I thought if we can think about where that line might be drawn and what different dimensions of legislative design would mean for different elements of the implied freedom analysis, that can be useful for legislative drafters. And I think equally, not only do TPALS give rise to interesting implied freedom questions, I think these laws raise interesting and difficult questions about the nature of the implied freedom and the nature of the assessment that the High Court undertakes in analysing that. And so I think it has sort of dual efficacy. It helps us think about these laws, and it also helps us think about the implied freedom. These laws aren't new. As far back as 1895, the UK introduced a law to prevent misleading and false political statements in relation to the private lives of members of Parliament and candidates in elections. When the first Commonwealth Electoral Act was introduced, it had some manner and form requirements around political advertising, authorisation statements that we'd all be familiar with today. That was expanded somewhat in 1911, and in 1912 it was challenged in the High Court. And there was a very emphatic statement from the court. Isaacs said, for example, Parliament can forbid and guard against fraudulent misrepresentation, which shocked the conscience to deny it. That law also had arguably the forerunner to today's truth in political advertising laws, which said any untrue or incorrect statement likely to mislead or interfere with an elector is an offence. But in 1981, the High Court read that down and said it was only relevant in relation to the act itself of casting a vote. So if you tried to mislead someone about the nature and form of voting, at a practical sense, that would be contrary to the offence. But it didn't didn't penalise statements in relation to the formation of political judgment that underlies that vote casting. Now, there's an interesting ANU connection here, because the Hawke government, while in opposition, proposed sweeping reform of the Electoral Act, and when they took government they established a joint select committee, and Geoffrey Lindell, formerly of this parish, made a submission saying, there's some concerns about these misleading electoral advertising. Now, in the committee report it's not entirely clear what those are, but I think put two and two together, the reading down by the High Court in Evans, I suspect, played a role in that submission. And the Select Committee said, we acknowledge this is an issue, we'd recommend Parliament ask us to think about it a bit more. The Hawke government sort of jumped the gun and enacted Australia's first truth in political advertising law, which was quite sweeping. But it was never used because in the subsequent committee report the following year, the committee said, this isn't a good idea, you didn't ask us to think about this, you've just done it, and we don't think that this provision is appropriately targeted, and it was repealed subsequently, although there was a dissenting report from one senator who said, you know, politicians shouldn't be able to lie, and we don't want that, but that was ignored. A couple of years later, South Australia got on the bandwagon, and again, it's not entirely clear why, and they, in second reading speeches, referred to that second report, which said these are a bad idea. So I haven't been able to figure out why South Australia introduced this provision, but it applies to people who authorise, cause or permit electoral advertisement that is inaccurate and misleading to a material extent, and it has to be a statement of fact. It doesn't apply to opinions. It has pecuniary penalties, has a defence for sort of didn't know and you know, that was reasonable to not know. The Electoral Commissioner can request a withdrawal and a retraction. There was a British study recently which case studied the South Australian law and interviewed all the political players and found that there was actually bipartisan support. So interestingly, at a federal level, this has been very politically controversial. In South Australia, both sides of politics support it, and the study concluded it had a benign impact but had prevented politicians from making claims that are demonstrably false. So it had some positive impact. It's been considered in Queensland, Victoria at a federal level, but hasn't been enacted until 2020, when ACT, the Greens, moved an amendment to reform the Electoral Act, and that takes effect this July. So it stays. And the Act will take effect from the next election. That brings us to the implied freedom. I'm sure you're all familiar with the current test as sort of blended together from Lange and McCloy and Coleman and Brown, etc. So the first question, does this impose a burden on political communication? You know, I think the obvious answer is yes, of course. This is a limit on political communication, and so therefore the first stage of the Lange test is satisfied, and that as much was certainly accepted in that first case, Cameron, although obviously before the more structured approach by the High Court. Interestingly though, in a case currently before the High Court of Zhang and Commissioner of Police, the Commonwealth, which involves foreign interference laws, the Commonwealth has argued that communication that undermines our system of government, you know, for example, which seeks to foment the violent overthrow of a democratic system, although political in nature, is not actually protected by the implied freedom. If that argument is accepted, then it obviously has parallels in the context of truth in political advertising laws. And so I think that's, you know, there is some force in that in light of the nature of the implied freedom. Laws that actively undermine our system of representative and responsible government perhaps don't have protection. I suspect in practice the High Court will be unlikely to abandon the analysis at this stage because of particularly the risk that a truth in political advertising law could chill speech that goes beyond just speech that is prescribed. But that will be an interesting development to watch. In any event, I would suggest that the laws have a modest burden because they are very limited in their application, limited class of people, limited period of operation, and limited class of communication, which has some relevance to the proportionality analysis. What's the purpose? Wasn't really clearly spelt out in South Australia, but I think we can sort of infer that it's to prevent false and misleading political communication and thereby protect the integrity of our political electoral system and debate. You know, back in 1912, the High Court accepted that as legitimate. Cameron more recently did as well. And I think you could even say that not only is this legitimate and therefore compatible, but actually is serving to enhance the system of government, and you can draw analogies there to the Banerjee case, where the High Court said the same thing, and again influences the proportionality analysis. So that analysis, is it suitable? I think it is rationally connected to the purpose at both a narrow level in terms of preventing misleading and deceptive communication, and then at a broader level in terms of upholding the integrity of the system. And I think you can analogize there to the Club case, where they talked about both a narrow purpose and a broader purpose and being compatible and connected to both. Necessity, I think there's a range of legislative choices that can be made, and so I think there are actually reasonable arguments that this is overbroad, and I'll give some examples. You could limit the scope. The federal law, before it was repealed, talked about untrue. I think inaccurate, as in currently in the South Australian and ACT laws, is arguably a broader category. You could have partially inaccurate as opposed to strictly untrue. Application, the Commonwealth law was limited to the relevant period. In theory, these laws apply all times, although obviously political communication in electoral context only occurs in an electoral cycle. You could also think about limiting it to just political parties and candidates rather than third-party campaigners who are currently all covered. I think there's plausible arguments. The test for necessity under the High Court's current approach is extremely stringent, and so therefore I think it's unlikely they'd meet that threshold. And similarly, the adequacy and balance, this is a real risk to our electoral system, as we've seen in contemporary developments. We can only look to the US to see that the risk that these things pose, it's a modest burden. Mason in ACTV warned against accepting as read what the government says in relation to restricting speech, but I do think it's unlikely on balance that a court as currently composed would believe that these laws manifestly outweighed the burden, and that was certainly the outcome in Cameron, although pre-Lange and McCloy, etc. All of which is to say, I think the current laws are probably constitutional. Justice Gageler has sort of struck off on his own and very vehemently criticised structured proportionality. He's not the only one, but he's the most strident and enduring of that critique. And he has this calibrated scrutiny approach. Now, in none of the High Court cases since McCloy in 2015 has Gageler differed as to the outcome from the majority, and so there's an open academic question, much of it played out in the Federal Law Review, about the difference between Gageler's approach and the majority approach in practice. Given change on the High Court, it's not theoretical, it's not impossible that Gageler's approach could gain ascendancy, and so I also in my paper talk about, well, is there any difference? And I actually think there is, and I think it's evidenced in this context, because under Gageler's approach, it needs to be closely tailored and reasonably necessary to achieve the purpose, whereas the majority requires significantly lesser burden and manifestly outweighed. And I think particularly in this context, where there's a range of legislative choices available, it's possible to imagine that difference could lead to the majority of the current High Court upholding the law and Justice Gageler invalidating it. I think on balance probably not on these particular laws, but I think Gageler's approach, because of the context and because of the way Gageler's scrutiny goes about its task, would lead to a more exacting scrutiny, even if the outcome's the same. But I think, particularly as you tinker with these laws, as is currently, being discussed at a federal level, the Gageler approach is going to lead to heightened risk of invalidity. As I said, these are live questions at federal political level and at a number of states, and so I think it's useful to think about, well, what does this all mean? And my paper sets out a number of ideas. I just want to touch on a few of them. My paper set out 6, really keen to hear other ideas because I don't think those are exhaustive by any means. I think it's fairly obvious to say the broader the coverage of these laws, whether in terms of substance or in terms of form, the heightened risk of invalidity because of the more speech being covered, the greater the burden, the less the necessity test is easily satisfied. There's a chilling effect issue, which I'm going to touch on. Evidence is an obvious point in Unions New South Wales number 2, 2019 High Court case. New South Wales had severely limited the expenditure cap of third-party campaigners, and the High Court invalidated it and criticised them for not thinking about what that meant. There'd been none of the usual parliamentary processes and committee considerations to satisfy a rational deliberation that even this cap would still allow sufficient third-party involvement in elections, and the High Court said, that's not good. And so I think for any parliament thinking of passing these laws, doing their due diligence is important. Interesting that neither South Australia or I think the ACT to the full extent you might have hoped did that. And then there's issues about, well, who's deciding what is truth and what about inconsistent application, which I'm both going to touch on. As I said, I think there is a significant likelihood that federal or other state TPALS will be broader. I think there's consensus that the South Australian law is narrow and limited, and therefore the efficacy is reduced. And so I think there's a question of whether they need to be more robust. One of the really interesting issues that arises then is the chilling effect that this has on speech that's not in fact covered, that might sort of fall within an overzealous administrator of the law, for example. Now, in the US, there are separate but related doctrines of void for vagueness and overbreadth, which both try and prevent overly broad, overly applicable laws from burdening speech. The High Court doesn't like US First Amendment doctrine, but in Bob Brown's protest case, said that of course vague laws are relevant because they necessarily impose a greater practical burden. I think the relevance for our purposes is vaguely worded prohibitions are going to increase the burden and increase the risk of invalidity, so very careful and tight drafting I think is certainly advisable. But I wonder, maybe this is being a bit optimistic, but I wonder whether these laws might lead to the court engaging a little bit more seriously with that issue of the chilling effect. I think in a number of these cases, they say, look, not relevant because it's an American doctrine. Now, as a legal doctrine, that's correct, but as a practical matter, these laws do chill speech that is otherwise legal. The Banerjee case involving a tweeting public servant, a good example. Many public servant friends have said to me as a result of that case, they're very careful with their communication on political matters. A very clear chilling effect. And obviously, the High Court's dogma that the First Amendment principles are not relevant overlooks that threat that are posed by some of these laws that they've upheld, and I think that is a particularly pronounced issue in this current context. And so I wonder whether more engagement with the risk could helpfully come about in litigation on these sorts of provisions. The role of the Arbiter is interesting here. In the ACT context, the Electoral Commission said they didn't want to have this role, and they were given it anyway. South Australian Electoral Commission has also said it's not very comfortable, but hey, in federal deliberations, the AEC has made similar comments. So there's an open question about who's the appropriate body. At the moment, both schemes, they have a role for the Electoral Commissioner, but that is only a recommendatory and procedural role. Of course, they need to act in an enforcement capacity, but it's ultimately the Supreme Court of both states making these judgments. I think that's relevant from an implied freedom perspective because there is a risk if the Electoral Commissioner made determinative judgments that had limited review, that would increase the burden on speech. Interestingly, in a recent case from the full court of the Federal Court, following on from the 2019 federal election, and this involved a Chinese language core flutes that allegedly had a misleading impact on voters. The High Court mentioned the former federal TPAL, the short-lived TPAL, and made a comment, sorry, the federal court, and made a comment that these could give rise to issues that are scarcely justiciable. I'm not sure I agree with that. I think if the standard is sufficiently clear, then of course there are going to be some thorny evidentiary issues, but misleading and deceptive conduct is not a standard unknown to law. Determining fact is not either. And so I'm not sure, I appreciate there's concerns about the politicisation, but I'm not sure I agree with that statement in the Garbett case. But finally, I think there's a real concern about whether third parties could have a role. There's been talk about, well, what about complainants having standing to bring, if the Electoral Commissioner doesn't do anything, to go straight to the court? It's been discussed at a federal level. That would significantly increase the implied freedom risk, and in the US, examples have been invalidated because of the ability to politicise the process and to increase the burden on speech by increasing the litigation cost associated with electoral advertising. So just to wrap up, interestingly, inconsistent application, again, another issue in the US. It's been a determinative issue in a number of cases. What happens if the Electoral Commissioner brings cases on a partisan basis? Not an issue we've had in Australia, but not removed from the realm of possibility. Or what happens if it's not as blatant as that, but it has a more subtle inconsistency because of, for example, the nature of political communication and advertising styles of different realms of the political spectrum, and that could give rise to some really challenging implied freedom questions, because constitutional challenges don't really engage effectively with that practical selectivity. Maybe you could bring a judicial review claim, in which case the law is very unsettled around the intersection between the implied freedom and administrative review. So scope, I think, in this context for future development. Interestingly, in the US, despite the First Amendment, there's a number of states that have these laws. It's never been directly confronted by the Supreme Court, but I don't think the jurisprudence bodes well. In a 2011 case involving stolen valour laws that prohibited false statements in relation to past military service, the Supreme Court invalidated that. Statement from Justice Kennedy for the majority, the remedy for speech that is false is speech that's true. Obviously that was said well before Donald Trump was in office. In the UK, the provision I mentioned at the beginning was challenged in the Woolass case, seeking to give it a much more expansive definition. It's limited to personal matters, tried to sort of include political matters in that prohibition, and the court read it down, but said that otherwise it was compliant with human rights standards in the UK. So I think in summary, I suspect that the South Australian and ACT truth in political advertising laws are constitutional. I think more expansive laws would give rise to significant constitutional risk. And I'll leave you with 3 quotes. I watched The Social Dilemma on Netflix recently and had a good quote about the fact that the truth is boring. Hannah Arendt, in a New York Review of Books article several decades ago, said that the deliberate falsehood has long been part of ordinary political communication. On the other hand, Lord Hobhouse in the UK said there's no human right to disseminate information that's not true. Would love your comments, because as I said, this is still a draft, so I'm going to take notes.
Two things that really struck me as quite interesting about this, and then I'll just open it up for questions. These aren't questions, but you're welcome to speak to them if you want to. But I think the first one is this question about, well, what is the truth? Because it has become so subjective. And I blame a number of things for that. I think the great problem is postmodernism. I think postmodernism has a lot to answer for. I thought when I was a child that we were on a journey towards enlightenment, but as Christopher Hitchens says, we're more and more tolerant of mumbo-jumbo. And I think as long as we are tolerant of mumbo-jumbo, I think it's a real problem because the truth has become so rationalised and such a point of subjective interpretation. So that's just a comment I would make about this difficulty that we're all going to have. I'd love the brief. As a barrister, I would love the brief on this because the fees are going to roll in while everybody goes around the buoy on, well, was it the truth or was it, what does it mean? And I understand Brian Schmidt wrote an op-ed on the role of postmodernism in changing fake news recently, like in the last month or so. But I think that's probably because I had a conversation with him that sparked that. I'm sure he was inspired by something. That's a lie, okay? That's fake news. I've never had a conversation with Brian Schmidt. But you'll all take that bit away from this. And then the second thing I was going to say that really struck me about this that I thought was quite interesting is I was just wondering, when does something become political advertising? Because if you do follow that 1911, 1912 kind of emanation of the advertising has to have a certain template where you then ascribe authorisation, this message was authorised by blah, 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 whatever party and spoken by blah, 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 that's political advertising. It's being flagged. But what if it's tweeted with all of that and then somebody retweets it and the retweeter has running an account on behalf of that party? Is that more political advertising? And what if the tweet then says something that then characterises a response to it as a lie? And I keep thinking about that whole brilliant piece of work that was done changing estate tax to death tax. And suddenly it's a lot stinkier to the left-leaning of us than an estate tax, which means if you're really wealthy, of course you should be taxed when you die. So anyway, these are just two comments. I think there's an evidentiary problem at the heart of all of this, and I think it's really human and subjective, and I find it really annoying, and I think it would be great if the world returned to some central canon, and if we had some idea about what's what, it would be really good. But I think that's what we're here for. Yeah. The academy, that role. And I think you've raised the right questions, Kieren.
Just on that second comment, so both the South Australian and the ACT Act define advertisement fairly broadly, print, radio, TV, online, etc. The ACT Act, for example, says electoral advertisement means an advertisement containing electoral matter, whether or not consideration, i.e. money, was given for its publication or broadcast. Now, I think that gives rise to questions about, if a politician says something on talkback radio or in a newspaper column, that's probably not. But if they tweet about it, if the tweet is promoted, sponsored by their political party, then it probably would. Mediscare was by text message. I don't think that would be covered. So I think that is going to be an open question as these laws develop and become more prevalent. Well, where do we draw the line? And as you said, a tweet, if it's not, is that electoral advertising? But what if it's from the politician's personal account, not the party account? There's a risk that these laws will be evaded by, clever marketing. And so, but equally, the broader, from a form perspective, the greater constitutional risk. So, I've been speaking to some political stakeholders on these issues recently. I don't envy their role, because drafting one of these that's both effective and constitutional is not easy.
Yeah, okay, that's really interesting. And I think also, if you're not the political party funding it, but somebody else is making the statement who has an interest in the political outcome, they might characterise it as a community service announcement. The community needs to know that if your dividends have already been franked, you don't want to pay more tax on them. Try explaining that to the electorate. And who cares? Yeah. Well, there's actually a lot of people should care about whether their dividends have already been franked. And disclosure, I'm on the board of Wilson Asset Management, and it's Jeff Wilson who ran that campaign very, very successfully in trying to educate the community about the outcome for them financially of a possible political decision. So I think there's so much grey in amongst all of this.